Hello! Many Latin expressions are used in legal English. Degrees in law in common law countries do not require students to study Latin. So, how do you know when you can or can't use Latin expressions in a legal context? The answer is easy. I have drawn up a list, and if a Latin expression is on my list, then it is hot. Otherwise, it is not. This list does not consider Latin words used in criminal law, but only focuses on areas which correspond to the Latin civil law. Here are the Latin words that are extremely common in the Anglo-Saxon world. If you want to be understood by English-speaking people, you should pronounce these with a typical English pronunciation. Ab initio, from the beginning of something. Bona fide, in good faith. Bona vacantia, goods or an estate belonging to nobody, ownerless property which by law passes to the crown or state. Caveat, a warning. Caveat emptor, buyer beware, a common law doctrine that places the burden on buyers to reasonably examine property before making a purchase. Cum orientis. The cum orientis rule states, subject to a court order, that if two or more people die in circumstances where it is not possible to tell who died first, the deaths are presumed to have occurred in order of seniority, so the younger is deemed to survive the elder. De facto, really or in reality. Et al, and others, or and the other people, and usually follows the name of a person or a list of names and represents the remainder of the group. Please note, never say et alia, et alias, or et ali, because this will confuse people. E.g., for example. Please note, never say exempli gratia, because this will confuse people. Et sec, and in the following pages. I.e., that is. Please note, never say id est, because this will confuse people. Inter alia, among other things. Inter alias, among other people. Obiter dictum. Obiter dictum is the same as obiter, a judge's expression or opinion said in court or in a written judgment, but not essential to the decision, and therefore not legally binding as a precedent. Pari passu, equal footing. In finance, pari passu means that two or more parties to a financial contract are all treated the same. Pari passu is common in bankruptcy proceedings as well as debts in which each party gets the same amount. Wills and trusts can also be assigned a pari passu distribution, where all the named parties share the assets equally. Per se, in itself or by itself. Per stirpes describes property divided equally between the offspring. If a parent who is a beneficiary under a will dies and the legacy goes to children in equal shares, the legacy has been divided per stirpes. Prima facie, at first sight or based on first impression. Quid pro quo. Beware, this may be a false friend. Please note the expression is quid pro quo, not qui pro quo. It means an exchange of favors, or a favor in exchange for something else, or an exchange of services. For example, in a quid pro quo agreement, the baker always exchanges loaves of bread with the butcher for beef. Quid pro quo is not used in English to mean a misunderstanding. Ratio decidendi. Rationale for the decision. The change of reasoning in a case that causes the judge to arrive at the final judgment. Sine die. To a later undefined time, with no date for the restart. For example, the meeting was adjourned sine die. Ultravirus. Beyond your powers. If a director of a company does something ultra-virus, then what has been done is invalid. Verbatim. Word by word, exactly. Vice versa. The other way around, the contrary. Thank you very much, and see you next time for more Poochie's Pills to improve your legal English.